Failure challenge. Good morning, Mr. Schofield.
Good morning, Your Honor, and may it please the Court. If I may, I'd like to take a moment to provide some context before I turn to the specific issues. This case concerns one of the Commonwealth's most precious resources, its shore. Prior to 1882, the public could literally swim, sail, and paddle across the area of tidelands at issue, even at low tide. That changed in 1882 and 1895 when the Commonwealth issued two Chapter 91 licenses which authorized Arno's predecessors to fill this area solid. Arno's predecessors did this work without the payment of even a single cent to compensate the public for the private interference with their water-based rights.
So if the filling of the tidelands was authorized, then what does that mean? Doesn't that mean that the court was correct, that there was no longer a property interest that the Commonwealth held in that land?
No, Your Honor, and I think that that's an important point to address, because lawful filling does not extinguish public trust rights. That's made clear by Boston Waterfront, by TRIO, the 1981 opinions of the justices, and Moot. In those cases, the filling was all lawful, but the purpose of the licensing is to protect and preserve the public's interest in the lands that have been filled, and to promote public purposes in economic development and commerce and maritime use.
So once it's filled, so I guess I have two questions. One, it's your view that the 1895 mean high water mark, is that where that's post-filling, right?
That was actually pre-filling. That was pre-filling. And that's located, if you look at the diagram at tab 8 of our brief, it shows all of the water lines. And that plan was generated and developed by Arno's surveyor when they went through the process of applying for a Chapter 91 license. And I think that point is significant because the trial court's decision was based in large part on the idea that somehow the existence of public trust rights and the licensing requirements would upset expectations created by the Land Registration Act. Well, the fact that Arno went through the process of hiring a surveyor, identifying the historic lines, superimposing his project onto that plan, and then applying for a Chapter 91 license shows that the settled expectation was, in fact, exactly the opposite.
Well, let me ask you this, and I really don't quite understand this, but if you look at the Boston Waterfront case, the line discussed is a line that was part of the, I think it's 1846, that there was a...
it's the Baldwin study. It was
yes, the Baldwin study.
Yes.
Okay. So I guess my question is, why doesn't that line correspond to what appears in the registration proceedings in 1922? That is the 1922 line.
I think that's another important point. It's because the Attorney General, in its answer, said that it was not objecting to the entry of the decree, provided that the same is made subject to any and all rights of the public. Now, the Land Court then went ahead and added the term mean high water mark.
But there was nothing in that record in 1922 that would show a different mean high water line.
Two responses, just to finish my prior point. The court, in its certificate of registration, expressly declined to determine any water line. The idea that that line was somehow adjudicated or decided back in 1922 is just patently false. Nobody contested the Attorney General's request that the parcel be subject to any and all rights of the public. Now, addressing your second question about what in the record shows where that line might have been, well, the examiners...
In the old record.
In the old record, 1922, which is what the trial court in this case was looking at to try to interpret what the Land Court in 1922 might have intended by including that term. Right. In the examiner's reports, if you look at those, and the one for the Gardner registration is at page 147 of the record, and the one for the heirs registration is at page 76 of the record, both of those examiner's report extensively detail the filling and history of these sites, and in fact indicate that the entire parcels were at one time Nantucket Harbor, and that the parcels were in fact below the historic low water line, not just the historic mean high water line.
So then the 1922 decree only determined who owned the fee simple, am I correct? It didn't say anything, it didn't say anything about interfering with the public rights. It was just saying who owned the land.
That's
That's
accurate,
my
Your Honor.
reading?
We do not dispute that Arno has title to this land. What we argue, and based on their certificate, is that the public's rights were expressly reserved at the time of registration in 1922. And the fact that
The Attorney General in 1922 said, no objection subject to that. It appeared that the certificate, or is that the word?
the certificate of registration, yes, Your
Certificate
Honor.
of registration that issued wasn't exactly what the Attorney General had said no objection to. That is, it put in the mean high water, as you just said. So, and there was no appeal. So does that matter?
No, it doesn't matter. It's important to remember that the Attorney General's request was not contested or disputed. Nobody disputed that request. The land court, when
What
it entered...
specific request?
The specific request was that the parcel be subject to any and all rights of the public. There was no indication in the Attorney General's request that that part of the request was limited to any location of the parcel. And then the land court didn't expressly decline to determine any water line.
Now, with respect to the land court's language in 1922 that said it was declining to determine the location of the water line, I take it the location of the water line did not determine the boundaries of the land to which the petitioner at that time was seeking to register the land.
I think there are two different issues. The boundaries of the land were defined by the harbor. The boundaries of the public and private rights are defined by the historic lines.
So that the certificate, the decree of registration, the decree of the court, did not determine the boundaries of the land to which he took title.
Parts of it.
The decree did not determine the scope of the Attorney General's...
The outer edge of into the water.
Yes, and it also did not determine any specific water line. It did not, and the addition of the term mean high water by the land court, I think there's no reason to suppose, given that it was uncontested, given all of the facts in the examiner's report that show that it was below the low water mark, showed that it was filled, given that the land court expressly declined to determine the water line, a fact that Arno and the amici, the real estate bar, both conveniently ignore in their briefs, and the fact that Arno's...
Just say that again. What do they ignore in their
They
briefs?
ignore the fact they ignore the fact that the certificate expressly declined to determine any water line. And significantly, Arno's predecessors also did not use the exclusive mechanism for determining boundary lines in the intertidal zone, which is located in General Laws, Chapter 240, Section 19 through 26. Now, that's the exclusive provision. It says that a petitioner for registration, if they want those lines determined, can ask the land court to determine them concurrently with the registration process. That did not happen in this case.
Well, you suggest that the phrase mean high water has to mean the historic mean high water line, right?
What we suggest is the term mean high water is ambiguous because it wasn't determined at the time.
I take it this is something that's used frequently in land court cases, so isn't there it doesn't, I mean, I don't know, I don't do land court work, but doesn't it ordinarily mean the mean high water line at the time of the registration? Wouldn't that be the normal read or interpretation of it?
I don't think that is the correct interpretation
Isn't
of
it
that.
the average of where the water goes out with the full moon and where it goes out at the lowest point? Isn't that
If
what it
we
means?
went and looked today at the property to determine the water lines, the present water lines, we would look at the average, yes. But
But if you were trying to figure out the original high water mark, what date do you use as the original? Do you use the beginning of Massachusetts? Do you use the Ice Age? What do you use?
you use, sorry to interrupt.
No, I'm
You use the important date in history is the date that the colonial ordinances were passed, and significantly the second part of the colonial ordinance, which was in historians believe that was passed in and codified in 1647, which has been interpreted as a grant to littoral property owners of extended their property to the historic low water mark.
Well, as a matter, I'm curious, is if you don't use the historic mark, and the land court's registration decree gives title between the mean high water mark and the historic low mark, isn't there some space in between the historic mark and the mean high water mark? I mean, that's not covered by the land court decree, which means that the public has a right to some slice of land.
Well,
out there.
it would be backwards. The historic low water mark is actually further landward than the present high water mark would have been in 1922. I think it's also important to note that the land court, trial court in this case, essentially relied himself on a fiction in that he did not interpret mean high water as being the actual present water line in 1922. He himself interpreted it as being some other line, unobstructed by the bulkhead that was noted also in the record. So so the idea that somehow the mean high water meant the present line in 1922 is not even questioned by the land court.
My concern is that if you're asking us to conclude that mean high water line means that's a term of art, that means mean high water line in 1647, that's one thing. I don't know whether that disrupts all kinds of land court or registrations that have been done over the last couple of hundred years. Or are you saying that in this case, where the public rights are implicated, we should conclude that it means mean high water line in 1647?
What we're saying is, in this case, the latter, that because of all the information in the record that demonstrates that this was all filled land, a point that's not disputed by Arno, the fact that the land court declined to determine any water line, and the fact that the legislature, the judiciary, the attorney general have always understood that the historic lines are what matter for determining the distinction between public and private rights. Now, that's documented throughout our brief. I think it's also...
Is there a question here of subject matter jurisdiction in the land court, absent of specific grant by the legislature to determine this particular issue?
I think that I'm not sure that I would phrase it as subject matter jurisdiction, but I think that the land court's determination has the effect of relinquishing public trust rights.
Or the land court could be saying that the Attorney General in 1922, I mean, it seemed to me the land court's
Did the Attorney
interpretation
General
was
have
that he
authority to
relinquished it.
extinguish the public's interest in these tidelands without a specific grant of authority from the legislature?
I don't think so, Your Honor. I think that's an important point.
I think the answer to that is no.
The answer to that is no. And that's why the land court's decision is inconsistent with all of the court's cases. For example, in Boston Waterfront, the court held that land below the historic low water line, like Arno's filled tidelands here, was subject to a public trust, impressed with a public trust that gave the public's representatives an interest and responsibility in its development. The land court's decision is also inconsistent with the 1981 opinions of the justices, Trio, and Moot. For example, in Moot, this court stated emphatically that only the legislature has the authority to relinquish public trust rights.
Go ahead.
And then only by express legislation. I think it's significant that the court said that in a case about landlocked tidelands, which include places like the Trinity Church and the Boston Public Library. It would truly be extraordinary if the Boston Public Library needed a license under Chapter 91, but Arno did not, when you can literally walk off the front of his property into Nantucket Harbor. Significantly, I think even under the trial court's reasoning and Arno's reasoning, the developer in the Moot case, North Point case, if he had merely registered his land, he would have won that case under their reasoning.
Could I just ask you this? If the record in this case had only, the 1922 record had only the line that was that was there,
I wouldn't just, there's no line on the plan that says this is the mean high water line.
But isn't there a line that you say runs into the bulkhead, and there's some disagreement about that?
No, there's no line there that shows the mean high, that's marked as the mean high water line on those plans. I think that's an important point as well. Determining the mean high water line, going back to your earlier point, is a scientific process. You look at, the changes in the mean tide over time, looking at the data collected by various scientists and agencies. You don't just determine it like the land court did in this case by drawing a line across a plan that was never designated as mean high water in the first instance, especially when the court expressly declined to determine that line.
Well, that's what I wanted to, that was the question I had. Assume you had a record where there had been no express declination by the court to determine the mean high water line, and it was pretty clear that there had been a determination, even though it wasn't the historic line. Would you be making the same argument?
I think it depends on the circumstances. If the Attorney General was a party to that case and he submitted the request asking that the public's rights be reserved, and the petitioner for registration disputed that location and requested that it be determined under the provisions in Chapter 240, and that process was actually decided and adjudicated, then yeah, that would be a tougher case probably. But that's not what happened in this case, and that's not what happens in as far as what I know in all of these registration cases. The Attorney General files a standard form answer in these cases. He could, I suppose, back then have contested all of these registrations, and that would have forced the petitioners of land to hire.
Why would he do that if he's reserving the public, any and all public rights?
He wouldn't. That's the purpose of using that language, which applies to the entire parcel. And if there's a dispute sometime later, it can be determined. I think it's important. This is the first time this issue has come up since the Land Registration Act was passed in, I think, 1898. Chapter 91 licensing has been occurring since 1866. Hundreds of licenses have been issued for unregistered land, for registered land, without this issue ever coming up. Even
You mean hundreds of Chapter 91 licenses?
Yes. And this issue has not come up because the common understanding is that Chapter 91 applies and the public trust rights exist unless they are expressly or extinguished by the legislature. This court has been absolutely clear about that. I think it's important to I see that my time is up.
You don't get the benefit of the people before you.
Thank you, Your Honors.
Thank you, Mr. Schofield. Good morning, Mr. Orloff.
Good morning, Your Honor. May it please the Court. Good morning, Gordon Orloff for Mr. Arno. And I think I'm going to get to hopefully all the issues you've just raised with Mr. Schofield, but the first substantive issue in the case and that you've been focused on is where are the public rights in Mr. Arno's land? And
well, do you agree with what the Attorney General just said, that no one disputed the Attorney General's request in 1922 that the parcel be subject to any and all rights of the public?
That's about the only thing I do agree with.
Okay, but you do agree with that.
But
okay.
What's important to me, and I think what's being missed here, is the purpose of the land court registration system is a final decree issues. That decree
But
vests
then you've got the
title.
public trust
Pardon me?
doctrine. You've got the public trust doctrine superimposed on that, right?
Well, the first question is, where are these public rights? And I absolutely disagree that the land court cannot determine the boundaries between private owners and the Commonwealth. This is not a question.
It's not a title question. Nobody disputes title. And it's not clear to me, at least it's not clear to me, that the land court is distinguishing between title, right, which can be overlaid by the public trust doctrine.
Yes, I think in most instances, in the Chapter 91 context, at least with respect to these licenses,
Yeah.
I believe the Chapter 91 licenses spring very clearly from title with a T. There are other public trust rights, such as the right of navigation, which doesn't apply here to this property we're going to construct, which is right off Easy
I don't know
Street.
about the fouling.
I don't know if if people can foul anymore, but
I don't know. There are lots of seagulls. No, I'm serious.
And they're pretty foul. Can I ask you this? You started off by saying you were going to tell us where the public rights are on Arno's land. Could you expand on that? Where are
Yes,
the
Your
public
Honor.
rights?
And let me just preface it by saying the question isn't what the Attorney General did or didn't do, and the question isn't whether or not the Attorney General can extinguish rights. The question is, what does the land court decree, what does it vest in Mr. Arno, and what did it reserve for the public? Because it does reserve some public rights. And the description in the certificates is a very interesting description. It's meets and bounds, and on both the certificates at issue here in 1922, there are very specific measurements. For example, on page 117 of the appendix is the heirs certificate, and they're similar. Heirs is a little simpler, and it involves more of our land. And there's down to hundredths of feet descriptions along certain aspects of the boundary. And then, as was observed earlier, the land runs to Nantucket Harbor, which means, by many, many cases, that just means to the low water mark of Nantucket Harbor, wherever it is.
Is there any land between the high water mark and the historic high water mark?
Yes.
The historic high water mark is above.
Yeah.
Yes.
So did the land court decree for registration affect any of that land between, in your view, any of that land between the mean high water mark and the historic high water mark?
Absolutely. And
Which land court are you asking about?
1922.
the original
And
decrees.
you say what the land court legislation did in 1922 was extinguish whatever public trust doctrine rights were in that space, correct?
Not exactly. What I say.
Okay, you tell me.
That's not at all how I'd phrase it. What I
No,
would
no,
say-
that's not how you phrase it.
what
That's how I
would-
phrase it.
Well, what I would say is
Okay.
the land court adjudicated. It didn't extinguish. It made an adjudication, as it's done in many other cases. Michelson found that there's registered land, and Commonwealth tidelands accreted.
I might agree with you. You're talking about the adjudication in 1922.
Yes.
Correct. I might agree with you, except that, I mean, maybe it turns on what that decree said, right? You start off with the meets and bounds, right? And then you get to the water, and you say that any and all public rights legally existing over the same below. Why is the same not the whole thing?
Well, the same as the whole thing, but it's below mean high water mark. And what I was going to say is, so you've got this description down to Nantucket Harbor, but then there are the side boundaries, and they say they measure on the upland. Upland is above high water mark. On the upland, about, so they're not exact, but about 56 feet. And on one side, and that's the common boundary, and about something else on the other side. So you have measurements, and you have the land court plan, which is at 121, which shows that about 56 feet, about 98 and a half feet, and it shows a watermark. I absolutely disagree with the Commonwealth.
Olaf, let me ask you this. Let's assume there hadn't been a legislation, right? And so in when was the original fill done?
In
1882 and 1895.
Well, let's say in 1882 and 1895, right? It seems to me, so here's my question. If in fact, in granting that license to fill, the original license or licenses, let's assume there's one, 1895, to fill, you have to have, at that time, an extinguishment of the public trust, of the rights of the public under the public trust doctrine. Otherwise, they continue onwards. If they continue onwards, even if the land court decreed that they had been extinguished, if in fact they had not been extinguished, and it seems to me that that's not what the legislation was about, maybe I'm wrong about that, how can the land court in 1922 extinguish existing public trust doctrine rights?
Well, what the land court decree does is establish title, and it reserves certain title rights for the public below mean high water mark.
Wouldn't those, in any event, be there in 1922? If you have a new high water mark, wouldn't the public trust doctrine rights be there in any event?
Right, and this sort
So
of
why do you have to accept it in a sign off on the Attorney General?
Well, because once, this is the difference in registered land, well, it's not the sign off from the Attorney General, it's the decree that vests title. And at that point, this governs who owns what and where. And encumbrances and easements need to be shown on the certificate of title, and that was the Boston Waterfront holding. There's a lot of interesting stuff in Boston Waterfront.
But why didn't the decree determine who owns what and where, subject to the public right?
It did, but subject to the public right below mean high water mark. So the only question is, what mean high water mark? And the answer is, under Jackson v. Knott and other cases, you look at the registration decree and at the
But
plan.
I asked you, and you agreed that no one disputed that the Attorney General requested that the parcel be subject to any and all rights of the public. And was there anything in that request that be limited to just parts of the parcel?
Well, he did observe in the Ayers case that the bulkhead, which is shown on the registration plan, was between low and high water mark. And that high water mark is what's shown on that's the only mark shown on the plans.
But I guess, and maybe this is what the Chief Justice is asking, let's assume that that's just wrong, that in fact, that the public trust lands, that the tide lands go much farther back. Land court is wrong. Attorney General was wrong. Legislature has said nothing about this. And you're saying that just the fact that there is a decree that's adjudication of this line extinguishes, with nothing from the legislature, extinguishes the public trust interests in whatever part of this land that would be wrong in my hypothetical.
That's a great question, and I agree with, and I'll explain why, with most of it, except I wouldn't say, I mean, it extinguishes the public right of ownership and the public easement. So those are part of the public trust rights. So the public trust is broader than that.
I guess I'm really talking about the
But-
easement.
Okay, the easement, yes. And that's what land court decrees do. And if the Attorney General at the time, if the Commonwealth wanted to appeal, the time was to do that in 1922 and say, hey, this decree is wrong. We have rights, the public has rights that go further landward.
If the
It's
legislature
res
has,
judicata.
and that, it doesn't matter that the legislature has done nothing.
It doesn't. And
what
this
is,
court
does
has...
it make a difference if what the Attorney General thought I'm sure it was he at the time, thought he was doing was, continuing whatever public trust rights there existed dating back to the colonial ordinances? It's not such an unusual issue.
Well, if you look at his answer, he's clearly thinking about the mean high water mark being where it's shown on the plan.
Why? You say that, but why mean shown on the plan? Which plan?
Well, on the registration plan, which was based on the petitioner's plan. So the Attorney General is looking at the petitioner's plan, and he says, there's a bulkhead between the low and the high water mark.
Wouldn't that have been true even with the historic? I mean, take the 1895 high water. I mean,
Well,
wouldn't that have been true
not
as well?
exactly, because when if you look at the plan attached to the Commonwealth's brief, this is a basin. So it's almost, you have to think of like topographically. There's a basin, and the low water mark is filled like this. And so if this is the bulkhead, the high water mark kind of circles around this basin. It's not as though it runs, the historic one, it's not as though it runs parallel to the bulkhead. Now, in other words, it didn't run parallel to the shoreline. There was a basin. So it's very confusing to look back at those early watermarks, whereas the watermark shown on the plan is very clear.
Just, I had it last night, Mr. Orloff. Where's the plan? Just tell me where it is.
Plan is 121.
Okay.
Appendix 121.
Okay.
Now, do you agree that the historic high water mark is the measure of what constitutes a tideland?
That's what the measure of what constitutes tideland, or where public trust rights usually.
Okay, so you agree with the view that it's the historic and not the present high water mark which measures the extent of the public tidelands? Or
Yes.
public trust, okay. And do you also agree that the historic watermark here was further landward than the high water mark in 1922?
Yes.
So how can it be then that anyone other than the legislature can extinguish the public trust rights to the public's interest in the tidelands between the historic high water mark and the the high water mark in 1922? I mean, I understand if you were to say to me that the land court is entitled to ascertain what the historic high water mark is, because that ascertains the extent of the tidelands, I would say somebody has to figure that out, and that may be properly the land court. But you're saying to me that the land court has the ability essentially to extinguish the public trust rights between the historic high water mark and the actual high water mark.
I'm saying the land court has the authority to adjudicate who owns what and where their rights are, and it did so in 1922, and there was no appeal. It's res judicata, and there's the Michelson case.
But maybe there was no appeal because the Attorney General believed that the land court couldn't extinguish those public rights in that area.
Well, I think with respect, that's in a sense it's the Commonwealth's asking to get in the time tunnel and go back, because the Boston waterfront case really changed things. The Boston waterfront case came after Mr. Arno purchased. And of course, the public trust has been around, but I think the understanding about extinguishing rights really is a much later concept.
And maybe I'm just not remembering it right, but I thought that the Boston waterfront case said there's a condition subsequent that's attached to this that isn't on any deed, or it isn't reflected anywhere, but it exists.
And it said, therefore, your registration certificate needs to reflect it.
Okay.
And that's res judicata there. In this case, which had already been decided, there was already a final registration decree.
Mr. Orloff, can I just, I've now got to 121. You say it shows the high water mark. Doesn't, unless I'm missing something. It shows water.
It shows water. It shows a measurement of...
No, it says a plan of land, and I take it that what that means is that Mr. Humphrey, who was the surveyor, said this is now filled land. Nobody disputes that, but it doesn't say high water mark.
Well,
so where am I to find that? Let's assume that there was a real dispute in this case between the 1922 low water mark and high water mark. Okay? That tells me nothing.
Well, what it tells you is if you look at the certificate, it says the boundaries to the upland. Why would the certificate, which says the registrant owns all the way out into Nantucket Harbor, all right, why would it also say, and here's the measurements to the upland? There's a bulkhead. It could have measured to the bulkhead. Instead, it measured the upland. The plan has those measurements. They're approximate, and it shows a water line between those measurements. There's really only one way to read that, and it's got to be the high water mark as extended in 1922 across this property. I submit that is unambiguous, that is the approximate location within a foot or so.
But was there an express declination to determine where the high, as Mr. Schofield says, was there an express determination express declination not to determine the high water mark?
I think that's reflected in the approximation. The land court does not usually have an approximate distance. And in this case, below, the Commonwealth both parties were given the opportunity to more specifically define the exact location, but there's no question that even approximately the building at issue here is far above that mark, so neither party accepted that invitation. But I really want to please focus just for a moment on, there are many other cases where this court has said, Commonwealth tidelands, we're adjudicating that those Commonwealth tidelands are now owned by private parties. And if you find that you can't do that, and I'll tell you what they are in a second, but if you find that you can't do that, you're undoing all those cases, and you're also undoing your own authority and the land court's subordinate authority to decide who owns and where the Commonwealth tidelands are.
Nobody's saying anything about ownership, right? I mean, if title means ownership, I don't think anybody's suggesting that your client doesn't have title to this property.
Well, title subject to what easements, to what encumbrances, and a registration fine, and what everyone seems to be concerned about is whether or not the land court has the authority to find where those public rights lie. And in fact, the court has authority in the Michelson case to say a registered landowner accreted got new title to land that was former Commonwealth tidelands. In the Nichols case from 1867, there was a finding that a wharf on Commonwealth tidelands constituted adverse possession against the Commonwealth of those tidelands. So the courts can and have consistently determined such rights.
Thank you, Mr. Orloff.